Balikan natin ngayon ang press conference sa DOJ. Nandun pa rin si Moira Encina. Moira?
Have been subject to the compliance with all the requirements for application for amnesty. Now, as far as our records, the records that we've seen so far, there are among the accused who were actually, there was a decision which was rendered by an acting presiding judge who took over, Judge Pimentel, and she approved the amnesty which was granted to some of the accused. But when I looked at the records, it did not include Senator Trillanes. So we're still in the process of looking at all other decisions, all Regional Trial Court Branch 148, as to other decisions that may have been rendered as far as the other accused are concerned, sir.
So the applications were presented to the court, pala, sir?
No, manifestations were filed with the court saying that the accused who had filed or availed of amnesty had complied with the requirements. These were filed by their respective counsel. So on the basis of that, the acting presiding judge at that time approved the said applications.
Thank you. Did not include.
As far as the order that I have reviewed so far this morning, it did not include the name of Senator Trillanes. But again, we're having our prosecutors in Makati check with Regional Trial Court Branch 148, check with the records to find out if there were other orders or decisions that were rendered pursuant to approving the amnesty applied for.
It was up for promulgation already, Dong. In this case, it was already up for the prosecution and defense were already completed, and it was already up for promulgation.
Yes, the decision, the case was already submitted for decision. In fact, if I recall, Judge Pimentel already came out, scheduled it for promulgation, and he had with him a copy of the decision. He was just about to promulgate the decision when there was a manifestation from the defense counsel stating that there was amnesty that was supposed to be granted to all of the accused.
Sir, anong ibig sabihin nun na kanina wala dun yung application ni Trillanes sa RTC? Ano ba?
Kasi there are, if you look at the case, there are about 31.
Hold on, sir.
There are about 31 accused in this case. Now, if all of them availed of amnesty, then naturally there would have to be a manifestation to the court informing the court that they had complied with all the requirements. Apparently, not all of them were represented by one counsel. So, depending on who filed the manifestation, the orders would come out. Now, what I'm saying is that based on what I have checked so far, it did not include the name of Senator Trillanes.
So walang application?
Well, not in that order. It would appear that in that particular order, it would appear that as far as Senator Trillanes is concerned, wala pang approval. So we're checking other orders of the court.
If mabubuhay uli yung kaso, sir, ibig sabihin, desisyon na lang yung kulang. Si Judge Pimentel, andyan pa ba, sir?
Wala na po. Judge Pimentel retired already, I think, in 2010. Okay, so there's another judge, Judge Soriano, if I'm not mistaken, who is the acting presiding judge of RTC Branch 148. And you are correct, if the case will be reopened, it is only for the purposes of, one, asking for the issuance of an alias warrant of arrest, and second, for asking the court to promulgate the decision, considering that the court had already previously acquired jurisdiction over the person of the accused.
Okay, sir. Do you need to apply for a warrant? Or AFP na lang?
Yes, warrant.
Yes, in alias warrant.
Alias warrant.
Right. After the proper review of the records of this case, and we have determined that it's something that is ripe for reopening, right, that there are grounds to reopen the case, then first order of the day will be simply to ask the court for the issuance of an alias warrant so that the person of the accused will be brought into custody of the court.
Sir, how soon yan?
We'll do it as soon as we can, as soon as we find all the records pertaining to this case. You will please note that this case happened 15 years ago, so we'll just have to look into archives and other, case records on file.
May sinasabi yata si Soto, parang di-discuss muna ng Senate kung i-aalaw.
Well, that's a matter for the Senate to discuss. No, I think the issue there is on the matter of custody in the meantime. All right, but as I have explained, the matter of privilege from arrest while Congress is in session, which it is right now, does not apply if the offense charge is punishable by more than 6 years, as in this case, because this is coup d'etat.
Sir, should the AFP and PNP arrest him now?
I'm sorry?
Should the PNP and the AFP
There is a directive coming from the President himself as Commander-in-Chief, and I guess it's something that has to be obeyed.
that has to be
Obeyed.
obeyed?
Right.
Sir, ibig sabihin pwede mangyari kung nangyari kay Senator De Lima?
Magkaiba yata yung situation, no? Yung kay Senator De Lima ay charges for regular criminal offense, no? But this one is amnesty being set aside. And of course, nandun yung charge naman ng coup d'etat, no? Violation of the law on coup d'etat, so prohibiting coup d'etat. So I cannot really say whether the two cases are, squarely on the same footing. Yes, sir.
Identify yourself.
Sir, Dexter po sa DZMM.
Hi, Dexter.
You mentioned nag-usap kayo ng Pangulo noong September 2 bago siya umalis ng Israel. Ano po yung direktang utos niya po sa inyo regarding this case?
No, it was only the executive secretary who gave notice to me about a proclamation that had been signed by the president a couple of days before their departure date. And so, being the designated officer in charge, I guess it was his duty really to inform me about this very important proclamation.
Being the OIC of the Office of the President, ano po ang utos niyo po ngayong araw?
Well, it's simply for the concerned agencies to implement what the President has directed. In Section 2 of the proclamation, he made two specific directives, and that one is addressed to the Department of Justice and to the Armed Forces to continue with the proceedings that were suspended, if at all suspended, at the time that the amnesty was granted to Senator Trillanes. And also another directive, this time addressed to law enforcement agencies, to cause the apprehension of Senator Trillanes so that he might be brought into custody.
May timeline po ba kayo binigay sa PNP or AFP for the arrest of...
No specific timeline, but this is in effect, and as soon as it is feasible to do it, then so be it.
Sir, yung court-martial, sir, if at all suspended, will then proceed. And then second, the prosecution before Makati 148 will also proceed. But sir, since Judge Pimentel already resigned, and there's a new presiding judge, what will happen to the decision written by Pimentel? It will not be the one that will be understood. It will be an entirely new appreciation by the presiding judge, sir.
It will not be the same because the decision that was rendered covered all the accused. So if this is only going to be a promulgation, it will only be as far as
Sir, maybe we have...
All right. Okay, so yung kasing decision na about to be promulgated apparently pertains to all of the accused, no? So dahil itong development na ito is something that pertains only to Senator Trillanes, then probably there might be some need to review yung decision that has been prepared before but not promulgated.
But based on the proceedings na lang, sir, there will not be a new trial, sir, parang review na lang on the proceedings as to the alleged participation.
In my opinion, since a full-blown trial, assuming that a full-blown trial has already been conducted, then I guess there will be no need to repeat. All of these are made of record by our courts, which are courts of record. And so any judge who will take over and promulgate the judgment need only go through the transcripts, the pleadings, the case files, and so forth and so on, without need to conduct a new trial altogether.
Sir, kasi may CIDG personnel na kayo sa Senate, so they can already effect the order.
They can actually. So and yeah, I think Senator Trillanes says he's ready. He's ready. So so be it. All right.
Sir, I may do
Yes.
As long, sir, people are quite surprised with this development. Is there such a jurisprudence when it comes to revocation of amnesties?
Well, as I said, this is not a matter of revocation. when you say you revoke, there's something that was actually given validly and you are taking it back for some reasons. But that does not seem to be the case here. This proclamation declares that the grant was invalid and void ab initio, right from the beginning. So you're not taking back something. You're declaring that something never actually validly existed.
Sir, Lawrence Tano, Radyo Sir, here.
Yes.
Radyo Pilipinas, Sir Lawrence Tano. Sir, if
Yes,
ever na
Lawrence.
makapag-comply po si Senator Trillanes dun sa mga requirements, pwede bang ibigay ulit sa kanya ang amnesty? Or magbigay ng
I guess that's a different matter altogether. You know, we're talking about executive clemency, and that pertains to the person who is the chief executive at the time that the application will be granted. No, so he'll be dealing with President Duterte this time if he applies, assuming that he will be willing to do that.
So, syempre, sir, ang perception nito, sir, hinahabol yung kalaban, di ba, sir, ng Pangulo. Sir, yun yung magiging political persecution. That would be the line, definitely, of
Well, we cannot really prevent people or Senator Trillanes from thinking that way. But from the point of view of government, if there is something that needs to be done, then it should be done regardless of the timing. Especially if an act is deemed void from the beginning. We're not talking about any prescriptive period here. The government is not stopped by a mistake that was done by its own officers, and a matter that is void or an act which is void from the beginning can be challenged and attacked at any time, no matter the amount of time that has elapsed.
So what prompted the review of OSC?
Can't really answer that, you know. But I guess this is really a matter of making sure that all necessary legal requirements in so far as important matters like this have been complied with. Now, as to what other reasons there might have been, I'm not privy to that. I'm sorry to say.
Sir, earlier you said, sir, you assumed, di ba, sir, na baka meron ding review doon sa iba. Instead, sir, take sure the others were granted amnesty, the MACL officers, some of them are supporters of the president, di ba, sir? So, but to your knowledge, sir, wala kang specific knowledge na meron na ongoing, parang you just assume.
No, I have no personal knowledge. I don't have any specific knowledge that such a review covering other people is ongoing, but I just surmise that in as much as something like this was reopened, then probably the same thing is also being done insofar as people who are similarly situated are concerned.
Sir, Daniel po from
Yes, Daniel.
Sir, sakali man, saan po ipupunta si Senator Trillanes?
Well, the proclamation says he will be committed to where he was before at the time that the amnesty was granted, no? So wherever he may be. If he was at the Makati City Jail at the time, then if the case is reopened and a warrant, alias warrant, is issued against him, then he goes there. If he was under detention within the premises of the armed forces because of the martial law proceedings then ongoing, then he will be restored or detained in the same location. It all was at the time that the amnesty was issued.
Sir, while waiting for an alias warrant, pwede bang sa Senate muna?
That's what I said. No, maybe that's the reason why Senator Tito Soto would like to discuss this with the rest of his colleagues. So we believe that's a fair and reasonable arrangement. In the meantime, that the prosecution, the DOJ, and the armed forces are still, reviewing their records. But there's already a directive to put him under custody. So I guess that's the best possible arrangement in the meantime. But he is not immune from arrest, as I would like to emphasize. All right, that's just for convenience.
Sir, the custody being spoken of in the proclamation is in terms of immediate custody. But since subsequently you'll be applying for the issuance of an alias warrant, then there has to be a return of the warrant, and therefore we will follow the same procedure that the court will now determine where via commitment order siya.
Yes, very true. Once the court acquires jurisdiction over the person of the accused, then his place of detention will also be determined by the court which acquired jurisdiction.
Secretary, nakapag-request na po ba ang DOJ ng alias warrant?
Di pa, kasi nga yung mga records, halukayin pa namin yan eh. 2003 case pa, and we got this proclamation only yesterday, so we need to take a look at the records first.
So sir, it's now na meron ng hindi na comply na requirements ni Senator Trillanes. So, can we say na yung grant sa kanya by the previous administration is irregular?
Void nga eh, not only irregular but void, no? So I cannot really answer for those for the people who granted the amnesty at that time. Remember that there was an ad hoc committee under Proclamation number 75 during the time of President Noynoy Aquino, which created this ad hoc committee for the grant of amnesty to those involved in the mutiny, in the Oakwood mutiny and the other incidents, no? And it was, I think, the approval of the applications for amnesty at that time was given by the DND secretary at that time, si Secretary Voltaire Gasmin, all right, as mentioned in the proclamation. So, well, if there was non-compliance with some requirements, but nonetheless, amnesty was granted, I think it would be for Secretary Voltaire to explain that. No, it's not for us to to dwell into that matter because that happened many years ago.
So, sir, going back to the requirements, no, he has to satisfy both or just one?
Yeah, both. Because I guess now I've not seen the form, but I suppose that form would contain a section where he would expressly admit that he's guilty of the offense charged, no? Because I would surmise na kasama yun because that form, application form, is under oath. All right? So such an important requirement like admission of guilt is something that should be contained in that form under oath. So to me, that is the more important requirement rather than the form. All right? It's the admission of guilt and that you are pleading for executive clemency.
Ibig sabihin, sir, even if he can prove that he did apply in 2011, pero wala namang admission, wala rin na valid.
Yeah, that would seem to be the case. Ang problema rito, parang meron yatang certain media statement si Senator Trillanes na parang sinasabi niya na dinidisclaim niya expressly yung kanyang guilt for any wrongdoing and that apparently according to the proclamation, hindi yan ang dapat na charge sa kanya but something else, no? Kung ano yung something else na yon, hindi niya sinabi. Pero apparently based on the proclamation again ay meron siya mga statements to the media before na sinasabi niya na hindi ito ang charges to which I will plead guilty. Something to that effect.
Okay. Sir, walang attachment ng admission of guilt dun sa application? Affidavit?
Ang tingin ko nga it might be in the form of an affidavit, all right, under oath attached to the form or incorporated in the form itself.
As long as under oath, Sec, no?
Yes, yun ang mahalaga dun eh. For something like that, it's got to be under oath.
Sir, this was his interview in 2011, quote, "We admit guilt as far as rising up against the most corrupt president," referring to who this country has ever had proudly. Does this qualify as an admission to the crime?
The crime charge is coup d'etat. All right, so there must be an express admission of guilt to the offense of coup d'etat.
So may mention ng coup d'etat?
Yes, of course.
Not just a mere uprising against the most.
Yes, because the elements may be different.
All right.
Sir, for those who are saying that this will create a chilling effect not only to the opposition but those who are regular tao who may be opposing this administration, that they can no longer verbalize their opposition and then things like this happen. What is the message?
No, it's not a question of political opposition. It's a matter of compliance with the law. All right, this is a matter which is provided in the Constitution itself. When the chief executive grants clemency, all right, all the requirements must be naturally complied with. So we're just following the rule of law here. If something was not followed before, then the government is not barred from making the proper rectification to such a mistake. All right, so that's how we view these matters. No? And this may happen again in the future, not to scare anyone, but just to ensure that all the laws are followed and obeyed.
Sir, I really comment, this is the third decision daw na nakalagay ab initio from the beginning. First is Sereno, second is the land resource with the and the third is for Trillanes.
So what is your question?
Ab initio, sir.
No, it just so happened that all of these matters seem to be invalid right from the beginning. Nakakataon lang yun. It's not a fad. I'm telling you, it's not a fad. It just so happened that all of these events, you know, these acts happen to be declared up after a serious review as void from a legal standpoint. Walang pattern yun. Ano lang yun? Nakakataon lang yun. Yeah. It's up to him. It's up to him. I will not teach him what to do. His lawyers are more, you know, are very capable of thinking what the legal remedies are available to him.
Secretary, clarification lang. If he can prove na from the very start meron naman talaga siyang requirement, can the amnesty be restored without him having to apply to the territory?
Let's cross the bridge when we get there.
But the repositories of all these documents are saying, sir, that they do not exist.
That's what the DND says. They have no records of such an official application. So if
Missing lang, sir.
sorry,
Missing lang.
well, we don't know. We presume that duties are regularly performed not only in the civil government but also, you know, in the military organization.
Sir, itong declaration ab initio, where can he challenge it?
Well, as
Right
I
now,
said,
as things
it's
stand
up to him.
Supreme Court,
I will not
I mean, as a
teach
matter-
him. You know,
as
he
a
has
matter
plenty
of
of lawyers. Yes, plenty of lawyers.
First impression.
Supreme Court, sir. Procedural question.
Well, I guess this is, you know, any act on the part of government is subject to judicial review to determine whether there has been grave abuse of discretion. So that's in the Constitution. So so be it. So bahala na sila. Pick it up from there.
Judicial review by
Judicial review in general. So depending on the hierarchy of courts, no, kung saan nila tingin na proper, depending on the importance of the issue, then they will have to decide where to go.
But the first venue for him, I think, is the Office of the President, sir, for exhaustion of remedies, sir. Kung he has to...
No, this is not an administrative case, all right? This is a matter of executive prerogative. This is executive clemency that we're talking about. This is an act of grace, all right? So we're not talking about a simple administrative case where you have to exhaust administrative remedies before you go to courts. All right, so this pertains to something that is purely personal to the president because it involves his discretion. All right, in the case of amnesty, of course, that's subject to concurrence by majority vote of the Congress. All right, in the case of amnesty.
Amnesty?
Yes, exactly. I'm saying executive clemency in general is a matter of grace on the part of the president. But with respect to amnesty, which involves political crimes, all right, the concurrence of a majority of Congress is a requirement.
this one, it doesn't need.
There was an issue, I remember, so before it was presented to Congress, there was no admission of guilt. Even way back, there was an issue raised.
No admission of guilt. So.
Because before you presented to Congress, all the requirements have to be complied.
Okay, all right.
Sir, this one does not need the concurrence of Congress.
Amnesty requires congressional concurrence.
But void,
Yeah, but you know, what will Congress concur to if in the beginning it was invalid? Okay.
Has there been an amnesty before na void, declared na void?
I'm sorry, again?
Has there been an amnesty before that was declared valid? Or is it really the first?
I do not recall of any that has happened in the past, but I'm not sure about that. We're talking about decades of executive clemency. There might have been, but I don't recall any where an amnesty given was set aside for being void ab initio.